Class suit. When the subject matter of a controversy is one of common or general interest to many persons so numerous that it is impracticable to join all as parties, a number of them which the court finds to be sufficiently numerous and representative as to fully protect the interests of all concerned may sue or defend for the benefit of all. Any party in interest shall have the right to intervene to protect his individual interest. The case of Liana Supermarket versus NLRC, GR number 111014, May 31, 1996. So the facts in this case are as follows. Liana Supermarket, as its name implies, is a departmentalized self-service retail market selling foods, convenience goods, and household merchandise with business outlets in Sucat, Parañaque, and Pasig City. Sometime in 1980, 1981, and 1982, it employed as sales ladies, cooks, packers, cashiers, electricians, warehousemen, etc., members of Private Respondent National Labor Union. However, in the course of their employment, they were allegedly underpaid and required, among others, to work more than 8 hours a day without overtime pay and deprived of legal holiday pay and monthly emergency allowance. Starting late 1982 and early 1983, they aired their grievances to petitioner through Peter C., its general manager, and Rosa C., its consultant, but were only scolded and threatened with outright dismissal. Consequently, they formed a labor union and affiliated with the Respondent National Labor Union. Thereafter, they demanded from petitioner recognition and compliance with existing labor laws. On March 24, 1984, Respondent Union, on behalf of its members, filed a complaint against petitioner before the labor arbiter for underpayment of wages, non-payment of overtime pay, monthly emergency allowance, legal holiday pay, service incentive leave pay, and 13th-month pay. On May 24, 1984, the complaint was amended since Respondent Union manifested through its authorized representative that it was intended as a class suit. 4 other cases were filed and were all consolidated. Respondent Labor Union submitted 2 lists of 136 workers, 73 assigned at Sucat and 63 at Pasig City. There were 85 original complainants in the lists. However, 16 complainants later filed motions to withdraw with prejudice, and 5 were found to be non-employees of petitioner. On January 27, 1987, 3 other complainants settled with petitioner and moved to dismiss their complaints. Thus, a total of 24 complainants were dropped from the lists, thereby reducing the number to 61. But 27 more employees submitted their sworn statements, thus increasing again the number of complainants to 88. Petitioner now asks how many individual complainants are there in these cases, whether 7 or 85. Petitioner claims that there are only 7 individual complainants in these cases whose names appear in the captions of the decision of the labor arbiter. Anent thereto, petitioner argues that Section 3, Rule 6 of the Rules of Court clearly provides that the names and residences of the parties, plaintiff and defendant, must be stated in the complaint. Similarly, Section 1, Rule 3 of the New Rules of Civil Procedure of Respondent NLRC states that the full names of all the real parties in interest, whether natural or juridical persons or entities authorized by law, shall be stated in the caption of the complaint or petition, as well as in the decision, award, or judgment. Moreover, according to petitioner, these cases do not fall under the term class suit as defined under the rules of court, because the parties are not so numerous that it would be impracticable to bring them all before the court. The Supreme Court held that this is a representative suit as distinguished from class suit defined in Section 12, Rule 3 of the Rules of Court. So what is a class suit anyway? The court explained that in rare requests of the heirs of the passengers of the Doña Paz to set aside the order of Judge Chinquanco, the court had occasion to explain class suit. What is contemplated is that the subject matter in controversy is of common or general interest to many persons, and those persons are so numerous as to make it impracticable to bring them all before the court. What makes the situation a proper case for a class suit is the circumstance that there is only one right or cause of action pertaining or belonging in common to many persons, not separately or severally to distinct individuals. The object of the suit is to obtain relief for or against numerous persons as a group or as an integral entity, and not as separate, distinct individuals whose rights or liabilities are separate from and independent of those affecting the others. The other factor that serves to distinguish the rule on class suits is the numerousness of parties involved. Okay? The rule is that for a class suit to be allowed, it is needful inter alia that the parties be so numerous that it would be impracticable to bring them all before the court. So in the present case, as the Supreme Court held, there are multiple rights or causes of action pertaining separately to several distinct employees who are members of respondent union. Therefore, the applicable rule is that provided in Section 3, Rule 3 of the Rules of Court on representative parties. A representative suit is akin to a class suit in the limited sense that the phrases found in Section 12 of Rule 3, one or more may sue or defend for the benefit of all, and the parties actually before it are sufficiently numerous and representative, are similar to the phrase may sue or be sued without joining the party for whose benefit the action is presented or defended, found in Section 3 of the same rule. In other words, both suits are always filed in behalf of another or others. That is why the two terms are sometimes used interchangeably. Apparently, respondent union, the labor arbiter, and respondent commission merely denominated the suit, although erroneously, as a class suit, when in reality it is a representative suit. Another case, Juana Complex Homeowners Association versus Phil Estate Land, GR numbers 152272 and 152397. This is a 2012 decision. The facts in this case are as follows. Juana Complex Homeowners Association, together with individual residents of Juana Complex 1 and other neighboring subdivisions, collectively referred to as JCHA, instituted a complaint for damages in its own behalf and as a class suit representing the regular commuters and motorists of Juana Complex 1 and neighboring subdivisions who were deprived of the use of La Paz Road against Phil Estate Land, Phil Estate Ecocentrum Corporation, La Paz Housing and Development Corporation, and Warbrid Security Agency and their respective officers. The complaint alleged that there were regular commuters and motorists who constantly traveled towards the direction of Manila and Calamba, that they used the entry and exit toll gates of South Luzon Expressway by passing through right-of-way public road known as La Paz Road, that they had been using La Paz Road for more than 10 years, that in August 1998, Phil Estate excavated, broke, and deliberately ruined La Paz Road that led to SLEX, so they would not be able to pass through the said road. That La Paz Road was restored by the residents to make it passable, but Phil Estate excavated the road again. That they reported the matter to the municipal government and the office of the municipal engineer, but the latter failed to repair. That the act of Phil Estate in excavating La Paz Road caused damage, prejudice, inconvenience, annoyance, and loss of precious hours to them, to the commuters and motorists, because traffic was rerouted to narrow streets that caused terrible traffic congestion and hazard, and that its permanent closure would not only prejudice their right to free and unhampered use of the property, but would also cause great damage and irreparable injury. Phil Estate filed a motion to dismiss, arguing that the complaint failed to state a cause of action and that it was improperly filed as a class suit. Phil Invest argues that the complaint was improperly filed as a class suit for it failed to show that JCHA et al. And the commuters and motorists they are representing have a well-defined community of interest over La Paz Road. They claim that the excavation of La Paz Road would not necessarily give rise to a common right or cause of action for them, since each of them has a separate and distinct purpose and each may be affected differently than the others. The Supreme Court held that the necessary elements for the maintenance of a class suit are the subject matter of controversy is one of common or general interest to many persons. The parties affected are so numerous that it is impracticable to bring them all to court. And the parties bringing the class suit are sufficiently numerous or representative of the class and can fully protect the interests of all concerned. In this case, the suit is clearly one that benefits all commuters and motorists who use La Paz Road. The subject matter of the instant case, that is, the closure and excavation of the La Paz Road, is initially shown to be of common or general interest to many persons. The records reveal that numerous individuals have filed manifestations with the lower court, conveying their intention to join private respondents in the suit and claiming that they are similarly situated with private respondents, for they were also prejudiced by the acts of petitioners in closing and excavating the La Paz Road. Moreover, the individuals sought to be represented by private respondents in the suit are so numerous that it is impracticable to join them all as parties and be named individually as plaintiffs in the complaint. These individuals claim to be residents of various barangays in Binyan, Laguna, and other barangays in San Pedro, Laguna. Okay, another case, Francisco Jr. versus House of Representatives. The Supreme Court in this case held that when dealing with class suits filed in behalf of all citizens, persons intervening must be sufficiently numerous to fully protect the interests and of all concerned to enable the court to deal properly with all interests involved in the suit, for a judgment in a class suit, whether favorable or unfavorable to the class, is under the res judicata principle, binding on all members of the class, whether or not they were before the court. Okay? Where it clearly appears that not all interests can be sufficiently represented, as shown by the divergent issues raised in the numerous petitions before the court, the case as a class suit ought to fail. The landmark case of Aposa versus Factoran, GR number 101083, July 13, 1993. So the facts in this case are as follows. The principal plaintiffs, now the principal petitioners, are all minors, duly represented and joined by their respective parents. Impleaded as an additional plaintiff is the Philippine Ecological Network, Incorporated, a domestic non-stock and non-profit corporation organized for the purpose of engaging in concerted action geared for the protection of our environment and natural resources. The complaint was instituted as a taxpayers' class suit and alleges that the plaintiffs are all citizens of the Republic of the Philippines, taxpayers, and entitled to the full benefit, use, and enjoyment of the natural resource treasure that is the country's virgin tropical rainforests. The same was filed for themselves and others who are equally concerned about the preservation of said resource, but are so numerous that it is impracticable to bring them all before the court. The minors further asseverate that they represent their generation as well as generations yet unborn, and consequently it is prayed for that judgment be rendered, ordering defendant, his agents, representatives, and other persons acting in his behalf to cancel all existing timber license agreements in the country and cease and desist from receiving, accepting, processing, renewing, or approving new timber license agreements and granting the plaintiffs such other reliefs just and equitable under the premises. The Supreme Court ruled that the civil case is indeed a class suit. The subject matter of the complaint is of common and general interest not just to several but to all citizens of the Philippines. Consequently, since the parties are so numerous, it becomes impracticable, if not totally impossible, to bring all of them before the court. The court likewise declared that the plaintiffs therein are numerous and representative enough to ensure the full protection of all concerned interests. Hence, all the requisites for the filing of a valid class suit under Section 12, Rule 3 of the Rules of Court are present both in the said civil case and in the instant petition, the latter being but an incident to the former. As you see in this case, generations yet unborn were represented. The Supreme Court held that this case has a special and novel element. Petitioners' minors assert that they represent their generation as well as generations yet unborn. The court found no difficulty in ruling that they can, for themselves, for others of their generation, and for the succeeding generations, file a class suit. Their personality to sue in behalf of the succeeding generations can only be based on the concept of intergenerational responsibility insofar as the right to a balanced and healthful ecology is concerned. Okay, so this case of Oposa versus Factoran was decided before the enactment of the Rules of Procedure for Environmental Cases. But take note that under the Rules of Procedure for Environmental Cases, now a person may file a citizen suit. A citizen suit is when any Filipino citizen is in representation of others, including minors or generations yet unborn, same wording as the case, may file an action to enforce rights or obligations under environmental laws. This is confirmed in the next case, Arrigo versus Swift, GR number 206510, September 16, 2014. The facts in this case are as follows. The petition is for the issuance of a writ of kalikasan with prayer for the issuance of a temporary environmental protection order under the Rules of Procedure for Environmental Cases, involving violations of environmental laws and regulations in relation to the grounding of the U.S. military ship USS Guardian over two Bataha reefs. The USS Guardian is an Avenger-class mine countermeasures ship of the U.S. Navy. The Supreme Court ruled that locus standi is a right of appearance in a court of justice on a given question. Specifically, it is a party's personal and substantial interest in a case where he has sustained or will sustain direct injury as a result of the act being challenged and calls for more than just a generalized grievance. However, the rule on standing is a procedural matter which the court has relaxed for non-traditional plaintiffs like ordinary citizens, taxpayers, and legislators when the public interest so requires, such as when the subject matter of the controversy is of transcendental importance, of overreaching significance to society, or of paramount public interest. So in this case of Arrigo versus Swift, it cited the landmark case of Oposa versus Factoran, where the Supreme Court recognized the public right of citizens to a balanced and healthful ecology, which, for the first time in our constitutional history, is solemnly incorporated in the fundamental law. The court declared that the right to a balanced and healthful ecology need not be written in the Constitution, for it is assumed, like other civil and political rights guaranteed in the Bill of Rights, to exist from the inception of mankind, and it is an issue of transcendental importance with intergenerational implications. Such right carries with it the correlative duty to refrain from impairing the environment. On the novel element in the class suit filed by petitioners, minors in Oposa, the court ruled that not only do ordinary citizens have legal standing to sue for the enforcement of environmental rights, they can do so in representation of their own and future generations. The Supreme Court further held that the liberalization of standing first enunciated in Oposa, insofar as it refers to minors and generations yet unborn, is now enshrined in the rules, which allows the filing of a citizen suit in environmental cases. The provision on citizen suits in the rules collapses the traditional rule on personal and direct interest on the principle that humans are stewards of nature. Let's discuss another case, Social Justice Society versus Slim, GR number 187836 and 187916, November 25, 2014. Challenged in these consolidated petitions is the validity of Ordinance number 8187, entitled An Ordinance Amending Ordinance number 8119, otherwise known as the Manila Comprehensive Land Use Plan and Zoning Ordinance of 2006, by creating a medium industrial zone and heavy industrial zone and providing for its enforcement. So this challenge ordinance was enacted by the Sangguniang Panglungsod of Manila on May 14, 2009. The petitioners claim that their rights with respect to the oil depots in Pandacan would be directly affected by the outcome of these cases. In one of the cases, in GR number 187916, Shell maintains that the petitioners failed to show their personal interest in the case and or to establish that they may represent the general sentiments of the constituents of City of Manila so as to be treated as a class suit. Even the minors, it argues, are not numerous and representative enough for the petition to be treated as a class suit. The court addressed this. It held that some of the petitioners are minors claiming to represent their own generation and future generations. However, unlike Oposa versus Factoran, the minors in this case do not appear to be representative enough of the interests of their generation as to consider their petition to be a class suit. The case of Spouses Imbong versus Ochoa Jr. The facts are as follows. RA number 10354, otherwise known as the Responsible Parenthood and Reproductive Health Act of 2012, was enacted by Congress on December 21, 2012. The constitutionality of the law was assailed by various sectors. The Supreme Court ruled that the consolidated cases are improper class suits that should be dismissed outright. A class suit is allowed under the rules if those who instituted the action are found to be sufficiently numerous and representative of the interests of all those they seek to represent. They must be so numerous that it would be impractical to bring them all to court or join them as parties. Lastly, a common interest in the controversy raised must be clearly established. These requirements afford protection for all those represented in the class suit, considering that this court's ruling will be binding on all of them. We should be specially cautious when the class represented by a few in an alleged class suit is the entire Filipino nation or all the adherents of a particular religion. This court must be convinced that the interest is so common that there can be no difference in the positions and points of view of all that belong to that class. Anything less than this standard will be an implied acceptance that in this important adjudication of alleged constitutional rights, the views of a few can be imposed on the many. The court cited several cases that were not considered as class suits. In the 1908 case of Ibanez versus Roman Catholic Church, 13 plaintiffs filed a complaint for themselves and on behalf of other inhabitants of the town of Ternate against the Roman Catholic Church for the proprietorship of an image of the Holy Child. The court held that the action could not be maintained. What number of the inhabitants of the town are members of the Roman Catholic Church, and what part are members of the independent Filipino Church does not appear. But it is very apparent that many of the inhabitants are opposed to the transfer of the image from the Roman Catholic Church. Under the circumstances, the 13 plaintiffs do not fairly represent all of the inhabitants of the town. Their interest and the interests of some of the others are diametrically opposed. For this reason, this action cannot be maintained. In the 1974 case of Matay versus Consolidated Bank and Trust Co., the court affirmed the dismissal of a complaint captioned as a class suit for failure to comply with the requisite that the parties who filed the class suit must be sufficiently numerous and representative. In that case, no sufficient representative parties had been joined. In rare request of the heirs of the passengers of Doña Paz, a class suit was filed by 27 named plaintiffs on behalf and in representation of the approximately 4,000 persons who are all close relatives and legal heirs of the passengers of the Doña Paz. The Supreme Court distinguished class suits from permissive joinder of parties. What makes the situation a proper case for a class suit is the circumstance that there is only one right or cause of action pertaining or belonging in common to many persons, not separately or severally to distinct individuals. The other factor that serves to distinguish the rule on class suits from that of permissive joinder of parties is, of course, the numerousness of parties involved in the former. The rule is that for a class suit to be allowed, it is needful that the parties be so numerous that it would be impracticable to bring them all before the court. Finding that the case was improperly brought as a class suit, this court or the Supreme Court concluded that it follows that the action may not be maintained by a representative few in behalf of all the others. Consequently, the court denied the authority to litigate in the form of a class suit. Okay, now in this case of Spouses Imbong versus Ochoa Jr., the court held that class suits require that there is a possibility that those represented can affirm that their interests are properly raised in a class suit. The general rule must be that they be real and existing. In constitutional adjudication, this court must approach class suits with caution. Otherwise, future generations or an amorphous class will be bound by a ruling which they did not participate in. Not all the elements for a proper class suit are present in the petitions filed in these cases. Petitioners James Imbong and Lovely Ann Imbong, for themselves and in behalf of their minor children, Lucia Carlos Imbong and Bernadette Carlos Imbong, and Magnificat Child Development Center Incorporated, filed their petition as parents and as a class suit in representation of other parents and individuals similarly situated. They allege that they are Catholics who have deeply held religious beliefs upon which faith their conscience is rooted against complying with the mandates of the Act. 4 persons and a juridical entity cannot be considered as sufficiently numerous and representative of the interest of all other parents and individuals similarly situated. That is what the Supreme Court said. Petitioners' Alliance for the Family Foundation Incorporated, represented by its president Maria Concepcion Noche, spouses Luistro, et al., invoked Oposa versus Factoran Jr. in filing their petition on behalf of all generations of Filipinos yet unborn who are in danger of being deprived of the right to life by RA number 10354. However, the Supreme Court held that the required common interest in the controversy can neither be determined nor proven in this case if those to be represented are yet to be born. It is true that in Oposa versus Factoran, intergenerational suits were introduced in our jurisdiction. However, this case must not be abused out of its context. Oposa is a novel case involving an environmental class suit. This environmental case involved minor petitioners who filed a complaint for the cancellation of all existing timber license agreements in the country. They were allowed to sue on behalf of future generations on the ground of intergenerational responsibility in relation to the constitutional right to a balanced and healthful ecology. The state of our ecology will certainly affect future generations regardless of ideology, philosophy, or standpoints. On the other hand, those who will only be born in the future may have different views regarding the various policy approaches on responsible parenthood and reproductive health. Hence, the commonality of the interest that will justify the presumption that the legal positions will be the same is not present. In its petition, Task Force for Family and Life Visayas Incorporated alleged that it is an association of men and women who have committed themselves to the protection of family and life, sanctity of marriage. Its members are Roman Catholics by faith and are spread throughout the Visayas region. The petitioners collectively seek relief from the impending threat against their children, their respective families, and the entire Filipino nation, their religious freedom, and other constitutional rights they foresee and make known in the petition. Petitioners, by no stretch of the imagination, cannot be representative of the interests of the entire Filipino nation, according to the Supreme Court. Not all Filipinos are Roman Catholics. Not all Filipinos are from the Visayas. Certainly, not all Filipinos have a common interest that will lead to a common point of view on the constitutionality of the various provisions of the RH law. Another set of petitioners alleged that their medical practitioners, members of the bar, educators, and various professionals who filed the petition as parents and as a class suit in representation of other parents and individuals similarly situated. They are devout and practicing Catholics whose religious beliefs find the mandatory provisions of the RH law obnoxious and unconscionable. The Supreme Court held that the basis for representing Catholics because their religious beliefs find the RH law obnoxious and unconscionable is not shared by all Catholics. Again, the class is improperly defined and could not withstand judicial scrutiny. Their views may not be representative of the entire class they seek to represent. Another set of petitioners, spouses Tatad and Pagya, allege that they are representing themselves, their posterity, and the rest of Filipino posterity, and they instituted their action in their capacity as concerned citizens, taxpayers, parents, grandparents, biological ancestors of all their descendants, born and unborn, conceived or not yet conceived, up to their remotest generation in the future within the context of Filipino posterity under the 1987 Constitution. The court held that 3 individual petitioners cannot be considered as sufficiently numerous and representative of the interests of the rest of Filipino posterity. There is no showing that future Filipinos will accept their point of view. No one can be certain of the interest of Filipinos in the future. No one can be certain that even their descendants will agree with their position. Consequently, a common interest on the controversy with future Filipinos cannot be established. In fact, petitioners Couples for Christ Foundation confirmed the existence of divergent opinions on the RH law among Filipinos when it stated that the Filipino people, of whom majority are Catholics, have a strong interest in the final resolution of the issues on reproductive health which has divided the nation for years. Another set of petitioners alleged that they were instituting the action as parents and as a class suit in representation of other parents and individuals similarly situated. They alleged that the RH law is oppressive, unjust, confiscatory, and discriminatory, specifically against the petitioners as parents, professionals, and faithful of the Catholic Church. So again, the Supreme Court held that there is no showing that these individual petitioners are sufficiently numerous and representative of the interests of those they seek to represent. The rationale for the dismissal of actions in these types of class suits is far from merely procedural. Since petitioners claim representation, the argument that they bring, as well as the finality of the judgment that will be rendered, will bind their principals. An improperly brought class suit, therefore, will clearly violate the due process rights of all those in the class. In these cases, certainly the entire Filipino nation, all the descendants of petitioners, all Catholics, and all the unborn will be bound, even though they would have agreed otherwise.